I would also like to mention that we will be recording the meeting, and it will be available for those who are not able to attend today to also interact with the content. So please do bear with us as we do that. I would like to invite two representatives from BRS to make a few opening remarks as we start. As part of the housekeeping issues, even as we go into that, I would like to remind the members that the discussions today are going to be limited to the content practice of number. Please, if you have any follow-up, if you have any issues outside the practice today, we urge you to come to the DLC meeting next month on the 19th. We do request members to remain muted during the session, and if you are not presenting or if you switch off your video, we encourage discussions as we go along on any topical issues. If you have any question, you can raise your hand or you can ask it on the chat. For those who are members of the Institute of Certified Secretaries, I would like to mention that the Secretariat has agreed that this training will earn you 2 CPD points. So we do ask you, because as part of the registration, we didn't capture your numbers. You do leave your name and ICS number on the chat, then we put this together and forward to the secretary for them to award you the 2 CPD points. The training is being hosted by Liroja Services. My name is Malachi. I'm joined by Nancy Muturi, who is also part of Liroja Services, and we are also joined by Emily Onyango. I will give them a few moments to introduce themselves further, their comment, then we'll go to comment from PRS. I'll start with Emily.
Thank you, Malachi. Good morning, everyone. So I'm Emily Onyango. I'm a senior and an advocate of the High Courts. Currently, I'm a banking and finance associate at Africa Legal Network Kenya. That's at Jawala and Kana. It's a pleasure to have you all for this training today, and I look forward to very interactive learning sessions. Thank you.
Good morning, everyone. My name is Nancy Muturi. I'm a member of ICS and an associate at Liroja Services, looking for an interactive for the next few hours. Thank you.
May I request Karen to unmute herself and say a few remarks. And then after Karen, Zachariah will say a few remarks from the others. Karen?
Good morning, Malachi. Good morning, members. Thank you again for this opportunity for us to join you. You are very crucial partners for us, both ICS and LSK, and we welcome this interaction. So we're looking forward to having a very good discussion this morning and of course, a learning experience. So thank you again.
Thank you, Karen. Zachariah.
Good morning. My name is Zachariah Mongi, Assistant Registrar of Companies. I'm glad to be here and welcome all for the training.
So members, I think one of the key reasons why we are calling out the registry staff representatives to make a few comments so that you know that what we are discussing here has also been looked at by registry, and this is the position as far as the documentation you need to prepare goes for the various changes that are outlined under practice note number 3. So without any further ado, having gone through the preliminaries, I would like first that we go into the content for today. We have approximately 3.5 hours to go through the content for today. We will have a break at around 11 for 10 or so minutes, and then we resume to finish the section of the presentation. So without any further ado, we'll take you through the object of today's meeting. We did indicate that we have a PowerPoint presentation that we will take members through. And once we are done with the PowerPoint presentation, we've prepared a few templates which we will have accessible to members. The templates are not prescriptive, but our understanding on what is expected of you as a practitioner by the registry. So you may adopt them as they are, or you may adapt them to suit your purposes, your practice. Then after that, we will go through the proposed amendment to the practice notes. When this document was first approved, it was agreed that it will be reviewed from time to time. Part of the process we are going through is at the current document and pick out areas that may need to be adjusted. We will present to this meeting what the three of us presenters feel should be amended, and then we will subject the document to you also. We'll share with you the link. Missed anything, you will have an opportunity within the next 1 to 2 weeks to also add your voice on the proposed amendments. Thereafter, we will have that reviewed by BM and then presented at the next JLC to be formally adopted as version 2 of the practice notes. So, and start the process. Yeah. The practice note number 3 cover annual returns, the filing of the annual return for companies, limited by guarantee, private companies and public companies. It covers changes, appointment, and any changes in directors, secretaries, holders, and authorized persons. It talks about companies that you should maintain of the authorized person, and any resolutions that can be passed, whether they are ordinary or special, and what type of resolutions then required to be filed with the register of companies. We then look into the changes in name, change in address, changes in accounting reference dates of the company. We look in the changes in the company memorandum and articles of association, alteration of share capital, which a number of us usually do go through. We will then have a look into filing of charges and debentures. We have mentioned on the templates we have with you, which are not part of the practice notes, and neither are these prescriptive. Later on, then we look at the proposed amendments to practice note number 3. So that will be the content that we purpose to cover for today. And right now to invite Nancy to take us through the annual return segment of the practice notes.
So I'll kick us off with the annual return. As you all know, annual return is a statutory requirement for both private Oh, sorry. So for the annual return, it's guided by the provisions of the Companies Act from section 705 to 708. So according to, by definition, the annual return is a statement of the company that entails the details of the company, that's the registered address, the registration number, the type of company, the shareholders, directors, secretaries, indebted, and among other things. So the key focus on this change is the return date, which according to the Act is the anniversary of the date of the incorporation or the date of the previous date when return was filed. While the date of the return is a date before the return date, or that has a grace period of 28 days before the return date. The signing date is the date that appears under Part 9 of the annual return, which is when the director or the company secretary signs. So in this case, the return might be for 2015, but it's been filed in 2019. So under Part 9, the date being signed in 2021 is the signing date. The filing deadline is the date 28 days after the return date. For instance, if the return date is 13th of July, you count 28 days, which after the 28 days marks the return being a late filing if it's not filed in the register of companies, which attracts an administrative penalty of 500 shillings. I'll also highlight the statement of capital, which over time has had different interpretation as to what details is to be captured under Part 9, Part 3, Part C1. So the statement of capital should capture the nominal value of each class of shares that is issued to the current shareholders and should not capture any unallotted shares. So the next part will go into chapter 2 of the practice notes, which covers the changes in directors and secretaries, and I'll be handing it over to Emily.
Thank you very much, Nancy. So I'll proceed to take us through the changes in directors. Now, Part 9 of the Companies Act provides for our company directors in detail. For the purposes of this meeting, we're going to be talking about changes in directors, and that is resignation, removal, rotation, retirement, death, insanity, and bankruptcy. These are events that may lead to changes in directors, and what, as practitioners, we need to be filing at the BRS, the company's registry. Now, when a director resigns, then you need to file the letter of resignation, the statutory declaration or an affidavit, and an extract of the board meeting, of the minutes of the board meeting, which has the resolution to the effect that the director has resigned. Then in addition to that, you also need to file a notice of cessation of office. On removal of directors, this is under Section 139 of the Companies Act. So first, there needs to be a special notice to the director informing them of the intended removal. And when you're filing, you also need to file proof that the notice was served on the director at least 21 days before the date of the meeting, resolving on the removal of the director. Then you also need to file the proof of service of the notice of the meeting. So there's the notice to the director, of the intention to remove him, and there's the notice of the general meeting to remove the director. And you also file the ordinary resolution removing the director, as well as the notice of cessation of office. When a director rotates or retires, then the documents to be filed are the notice of cessation of office, that's from CR9, and the ordinary resolution in CR19. Now, in the event of death of a director, then you'll file the notice of cessation, CR9, and a certified copy of the death certificate. When a director is unable to hold office as a result of insanity, then you need to file a report as provided under the Mental Health Act, and also file a notice of cessation form in the form of CR9. In the event of a bankruptcy, then you need to file CR9 and a copy of the bankruptcy order issued under the Insolvency Act 2015. Now, under Section 138 of the Companies Act, directors have a duty to notify the Registrar of changes in directors. That is why it is very important that these changes are actually notified to BRS. And in the event the directors or the company fails to notify the registrar, the statutory penalty is not exceeding 200,000. And in terms of filing, all appointments and resignations of directors are filed through the online platform. So that's it for the changes in directors. Please feel free to raise any concern or question you may have as we go along, so that they can be addressed based on the theme at the moment. Thank you.
I think the emphasis on the changes in directors usually is on removal of directors, where there is a lot of back and forth between practitioners and the registry. Now, I think it should be important to note that when you are doing a removal, it's a process that takes at least 28 days to be completed, and the practitioners need to have documentation proving that they have followed that process. So, for example, when you do the special notice, it should be important to note that these are not paper minutes. These are not documents you prepare, sign, and send to the registry to be recorded. You have to follow through, invite this director to the meetings, actually hold the meeting, and retain proof that you followed the due process. Now, the filing for all this is being done on the BRS platform using the resignation workflow. We did discuss for this to be enhanced so that there's a separate workflow for each. So if you're filing a resignation, members usually don't have a problem. If you're filing a removal, rotation, retirement, death, insanity, or bankruptcy, what you need is, in the place of letter of resignation, attach a relevant document for that change. For example, if it's a removal, you could attach proof of service of the special notice, and then in the place of affidavit, you attach proof of service for the notice of the general meeting. Then the other documents are attached in their relevant places for you to make this application online. So you will note that there is no manual in the manual services. Changes in directors is not included because you can achieve this on the live environment of the BRS portal. We can continue.
Thank you, Malachi. I think there's a question in the chat box. Ken is asking, on the death of a director, is it necessary for the certificate to be certified by the registered person? This has been required in certain instances by the BRS team.
The reason why this is required is because there has been an increase in fake documents being presented. So the registry is evolving to add more requirements depending on the quality and the veracity of the documents they've been receiving. So where members are being requested to provide these certified documents, it's because there is a problem with what the practitioners are submitting at the registry. So It is now a requirement, and please do note that the registrar has powers to request for additional documents to support notifications that are being made with the registry. So these additional requirements, like certified death certificates or affidavits when one is changing particulars of directors, specifically telephone number and email address, is necessary to curb certain mischief in practice.
Thank you, Malachi. There's a comment on the need to provide for death occurring outside Kenya, but there's also another question on what happens if the director signs transfer forms before their death.
There is this agreed requirement of the law that no one should meddle with an estate of a deceased person, as to the extent that it's considered meddling. If one was a nominee and you have nominee documentation proving that they were actually nominees, then it will be at the discretion of the registrar to accept that notification or not. However, if you do not have sufficient documents to back the position that this director was a nominee, then whether they signed a document or not, that can still be questioned, whether that will amount to meddling with the estate. A lot of applications really, depending on how it is done and how it is submitted, can elicit different reactions based on the quality or the timeliness or who is actually submitting the application with the registrar. So some of these issues are not unique across the board, but are taken on a case-by-case basis. But what we are presenting today are the agreed processes and documentation to effect a change in director. So where there is a death, at the minimum, you are required to provide a CR9 and a copy of the certified death certificate for that director.
Right. Malachi, there are still many questions coming, so I think you let me know when to pause.
Whether a director is resident or not, you need a death certificate. If they're not resident, then you need that death certificate notarized from where it's coming from. So you will not be sent to the register of deaths in that country. So far, I've not heard of such a scenario. In the removal bit, can proof of service of the notice to the director and proof of service of the notice to GM be the same thing? Those are not the same thing. The special notice comes way in advance of the notice for the AGM. Now, if you provide proof that you served the director specifically, both documents, you can have one proof, but in that proof, then you need to indicate that they were sent together. But ideally, you should specifically show proof that you served the notice to this director of the motion to remove them, and then show proof that you sent the notice of the AGM to everyone who is a member of the company. Now, if you combine those, it might be very easy to lose sight of one, whether it was really done or not. So the mischief in this would be proving that the proof of notice of the AGM or EGM also sits for the removal bit. So because of the specificity required to show proof that you served the special notice to the director, it might be lost when you try to then show that we sent the AGM notice, so we also sent it automatically. So the two, in my view, should be handled separately. So we've talked about signing documents before death, a director who is outside of the country, proof of notice. where a director is based abroad and resigns, difficulty in obtaining affidavits. What do we do in such a case? So if your director purportedly resigned, but you can't get documentation proving that they resigned, then the resignation option is not available to you. So you need to then explore whether you can go through the removal process so that you can have full documentation to support the cessation of office of that director. For a change in BN proprietors in event of death, please advise why you require confirmed grant for the estate. Unfortunately, the practice note we are handling today does not cover BN proprietors. So like I said, let's restrict our questions to the provisions of practice note number 3. If we can continue.
Thank you very much, Malachi, for your responses to the questions. So I'll proceed to take us through the changes in secretaries. Now, it's important to note that changes in company secretary can either be through resignation or removal. So, right. Now, when a company secretary resigns, then you need to file the letter of resignation and an extract of the board resolution together with Form CR13. When they're removed, then you file a CR13 and an extract of the board resolution for their removal. Now, for verified companies, the changes in secretaries can be done online on the eCitizen platform. However, for unverified companies, the changes are done manually in relation to company secretaries. So unless there is any question to that end, I'll let Nancy proceed with the changes of particulars of a director or secretary.
Just a comment on the secretaries, if you can go back. There has been questions over time where company secretary has resigned, but they don't have a board resolution to support their resignation. How do they go about it? Now, we have discussed at the JLC, and the consensus is that these issues will be handled on a case-by-case basis. But the general provisions of the Act is that notifications to the registrar on any changes in the company is to be made by the company, and the representative for the company is the board of directors. So if you do not have authority of the board, then you do not have authority to make any notifications for and on behalf of the company. So where you have resigned and you've served your notice of resignation to the company and they're not taking any action, then you can reach out to the registrar on a case-by-case basis for the registrar to then consider whether they will process your resignation without a board resolution or not. There are certain motions that the registrar will take in the back end to verify and confirm that indeed you've resigned, but the company is not doing their duty, and then to probably require them to do the necessary to update the registers, the register of secretaries of the company. So on the matter of resignation without board resolutions, there is no provision for it, but you can reach out to the registrar on a case-by-case basis to see whether your case in particular can be considered. There's a question on the platform, who is sometimes you link a company and a CS is included, yet the company has not appointed their CS. So you are a CS to the extent that a Form 203A or 203 was provided. Whether it was done with your knowledge or not, that's a different discussion. But we are aware, and practitioners are aware, that there are members who have in the past allowed their name to be used either intentionally or their names were used without their knowledge and was provided to the registrar, especially during that time when company secretaries were mandatory for all companies. Now, if that was the case, then the notification of your appointment was made by the company. Now, if you are of a contrary view, then you can take it up to make sure that it is undone. But provided a notification was done
with the registrar that one is the secretary. During linking, it is that secretary on record who has to be linked. If that person is not known to the company, then you have to process the removal of the secretary and then proceed to appoint the new secretary and then link the company with the correct officials as of the date of linking. Who is responsible to generate CR13? Is it ongoing secretary or incoming? My tech will be incoming secretary, because the moment you are fired, removed, or resigned, you cease to be an officer of the company. So on what basis are you going to do the notification? Unless the resolution of the board specifically authorizes you to attend to the notification. So best practice, I believe, should be the incoming secretary cleaning up the records of the company on the appointment to make sure that the correct officials are notified to the registrar. How about resignation of secretary where a company has been placed under receivership? If you are a secretary and you are appointed by the board and the powers of those board of directors is suspended, who is going to receive and accept your resignation? I think I'm posing this question back to Enid to think about. The powers of the board are suspended on the appointment of the receiver. So the appointer for the secretary is the board. The receiver does not take up some of those duties of the board, but they take up the caretaker role to either turn the company around or dispose of the assets of the company and distribute the proceeds to the relevant persons. So I can't give you whether a response of yes, whether you can resign during receivership, but because there's no one to process your resignation or to receive and approve your resignation and make the necessary notification to the registrar, my take will be for as long as the company is in receivership, unless there is an order to reconstitute the board and change the secretary, thereafter you remain a secretary to the company for the duration that the company is under receivership. But if there is any comments or any other views from members, this is a learning session. Please feel free to share or let us know of your view. There's a comment, lodged a resignation. There's a comment from Mbeja, the resignation of a company secretary where the board has refused to pass a resolution approving his or her resignation, where the engagement has been terminated, but the board maintains the secretary. Now, the secretary is appointed under the terms agreed by the board of directors. Now, if you are appointed for a term of 1 year or 2 years and that time lapses, it's upon the board to formally then pass a resolution to update the register of secretaries to disengage with you. Now, the mere fact that the letter of engagement has elapsed until the register of secretaries are updated, I think you are still secretary. There's a comment, or is this a question? This is a question. I lodged a resignation of CS application on the BRS platform, but was advised to link the company first. However, the system won't accept the linking application because of the pending resignation application. The system brings up an error stating that an application is pending. How can this be remedied? I think this is an issue with BRS. It's not on the practice note, but we have agreed with BRS that if you are doing linking of a company and the particulars as of today are different with what the registrar has on her records, you, on a case-by-case basis, having agreed with the linking team that those details are different, you can be allowed to process any of the changes that have since happened in the company to bring the registry records up to date to reconcile that with the information held by the company, then proceed to linking. Now, the linking team cannot proceed until the changes team have processed the change. So my take on this is you need to follow up with the changes team to process the application you made, I believe manually. Then once that is processed, the changes team can then proceed. There's a question taking us back to the annual return. I think when we are going through the template documents, we will address the question from Effie. Can the date of return be a day before the return date? Quick response is yes. And it can be even 28 days earlier. And it can be the date of the return date. So can we continue?
Yeah, sure.
On the changes in particulars, changes of particulars of a director or secretary, this is done through CR7 for directors and CR8 for secretaries. All changes of a director's particulars are filed on the manual platform. Now, CR7 is change of particulars, CR8 is change in residential address. We have discussed this, and if I am a director and I change my PO box address, there's no need for a board resolution to confirm that I've changed my PO box address. Now, there has been a lot of mischief on this in the recent past, where people change telephone numbers and email addresses of directors when they are about to do a change, so that when the registry reaches out to those people, then they reach out to the desired email address and telephone number, so that a third party provides the response as required and the change is processed. Now, to cure that mischief, the registry now requires that where you are changing the telephone number or the email address of a director or a shareholder, you need to provide an affidavit sworn by that director before a commissioner forwards. Now, this is to add an additional layer of ability to verify the authenticity of the changes being notified to the registrar. So this is something that practitioners themselves are bringing upon themselves. So please do take note that going forward, if you are changing the telephone number or email address of a director, you need that director to swear an affidavit before a commissioner forwards, and the registrar of companies can then reach out to that commissioner forwards and then confirm. So please do inform the person certifying the document that because they're putting their name to it, the registrar can reach out to them to verify. For secretaries, a similar approach. For changes in particulars, you do CR11. For change in residential address, you do CR12. Now, usually there is not a lot of mischief on this, so no affidavit is required presently. Now, the changes in residential address and changes in particulars currently is done through the manual services workflow. It's not on the live environment. Now, changes of particulars of a shareholder is being, we agreed at the JLC that we will adopt or adapt. I think it's more of adopt from CR7 for directors to notify on changes in residential address, to notify on changes in not residential address, changes in PO box address and other particulars registered with the BRS, changes in telephone number, changes in email address are done through Form CR7, and this is also available on the manual services platform. The authorized person, if you ask yourself, who is an authorized person? This is the person other than a director and a secretary who can apply to the registrar for certain changes to be made. And in principle, this is targeting advocates who are processing transactions on behalf of their clients on the BRS platform. So you need a board resolution and a letter duly signed by an officer of the company confirming that you have been appointed, whether it is for a general purpose where you can do all changes that a company secretary or a director could do, or if it's for a specific purpose. An authorized person could be appointed to process a particular changes in directors or shareholders in the company and nothing else. So in your letter, you need to then ensure that it is clearly outlined what powers has been delegated to you by the board of directors. Now, all the changes, as I've mentioned, are done on the manual services platform. If you can continue. On appointment of directors, there are three different ways in which a board member of a company can be appointed. And this is usually outlined in the articles of association. So please do check your articles whether which one of these applies for your specific company. Where the appointment of a director is done at a shareholders or a members meeting, you need to file Form CR6 and CR8, which are the standard forms for all appointments. Then you need to file a form of ordinary or special resolution and a letter of consent signed by that director agreeing to act as a member of the board of directors of the company. So the letter of consent has to be in writing and signed by that person. Where the appointment is done at a board of directors meeting, usually to fill a casual vacancy or for whatever reason given under the articles of association, the standard forms are required. Then you need an extract of the board meeting appointing the director, and of course a letter of consent. Now, for companies that are parastatals or other types of companies that are under the control of the state, appointment of directors is usually done through a gazette notice. Now, if you are doing a gazette notice and it runs, it has been published, yes, you will give the standard statutory forms. You need to give a copy of the legal notice published in the Kenya Gazette, and of course, a letter of consent signed by that director being appointed, or each of the directors appointed. Now, please take note that the support documents, depending on the type of appointment you have, will vary depending on your company, and the registrar is open to the different ways in which a director can be appointed. So this is outlined in the practice note. Please do check that section dealing with appointment of directors on the specifics that are required. Now, we are giving you this process. For example, appointment of a director at a general meeting. There is a lot that goes behind it before you get to preparing these documents. For example, is it an annual general meeting or is it as EGM? What are the notice period for those meetings? What is the quorum requirement? All those, we are assuming that you as a practitioner, you would have taken care of all the preliminary requirements before you get to the point where you're actually preparing the statutory documents. So where this is not clear, please do consult with your peers on exactly what is required so that you do not have defective minutes in the first place before you get to the notification stage. Since I am not seeing any questions on this, I am assuming members are okay with appointments. On appointment of alternate director, This is done on the manual portal, and alternate directors can only be appointed by the board of directors, and they are nominated by an existing member of the board. So there has to be a letter of appointment signed by the principal director or substantive director, an extract from the minutes of the board confirming the appointment of the alternate director, and a letter of consent signed by that individual agreeing to act as an alternate director. So if you go to the manual services portal, you will find a section where you attach all these required documents and you pay the prescribed fee. We've also followed up for this to be included in the next through the BPR, business process reengineering. And we do hope that with time, we will be able to have this properly done on the live environment while the developer is onboarded. Nancy will take over from here.
As relates to the appointment of a secretary, a secretary is appointed by the board of directors in most cases, and the documents required to be filed with the register of companies is the notice of appointment of a company secretary, that's from CR10, the notice of company secretary's residential address from CR12, the extract of the board resolution appointing the secretary. And in this case, a secretary can be an individual or a firm where there are two partners who will serve the board member, the board or the company in general. And also the other requirement is a letter of consent to act as a secretary. This is usually omitted, and when attaching the CR10, we've shared a template on this, which any person may adopt it for future appointments. Where companies have not been verified on BRS, may use the manual portal to file the appointment of company secretaries, and also resignation where company has not been verified on BRS. If there's no question, I will proceed to the next slide where we discuss the service address and the residential addresses. So for the service address is where documents may be served to a director or an officer of the company, and can be the same as the residential address where maybe the company has not formally started operations and they don't have a formal office. Or the same service address can be the registered address of the company, which is used during operation or may be changed from time to time. For the residential address, this is protected information and it's not public information, and therefore cannot be accessed by anyone unless the officers of the company or the state agencies that have the authority to access such information. So when it comes to the register of directors, there's also a requirement to have a register of residential directors' residential address. So in this case, the register of address contains the names of the directors, the nationality, the date of birth, the occupation, the service address, and there is or the residential address. If the director is a corporate body, it contains the corporate name, the registered on a principal address, the legal form of the company, and the governing law of that particular type of corporate. The register of director's residential address contains the usual residential address of every natural director. As mentioned above, it's protected information. Any changes regarding the residential address of a director for now can be filed through the manual process as mentioned earlier by Malachi.
Just a comment on the residential address. You will note that we've indicated that in the register of directors, you can have the service address being the residential address of that director. Where this is the case, the Act does allow the registrar of companies to redact that information so that it's not available when one does a public search for that company. So residential address is protected information to the extent that even if you have it as a service address, the registrar will then make it not available to the general public. I think it's good to separate the two, where register of residential address is not available to the public, but we are also saying that that information may also appear in the public register. But if the registrar then realizes that it has been presented in both registers, then the service address may be redacted so that the residential address is not available to the general public when they do a search on that company.
The next, we discussed about the change of registered address. This is also the principal address of the company. So from time to time, the company may change the registered address. In this, following through the BRS, you don't upload any form, although the form recognized to change or notify the register of companies is the form CR16. It's auto-generated and requires whoever is filing the change, if it's a director or a secretary, to receive a code verifying that they're actually changing the registered address. Also, the board resolution is not required, but for good practice, this should be noted at a board meeting that the address is being changed for records purposes.
We are very happy with the registrar that they don't require a physical form to be downloaded, signed, and then uploaded back. And we made that point known to the registrar. However, because Form CR16 is a prescribed form, the registrar did indicate that they will reconsider this when they are doing the BPR, whether this will be changed in the next version of the system or not. But the way it is now, some of us are very happy with the way this is seamless, and there is no requirement for back-end review. You change the registered address today, you provide the one-time password received through SMS, and it's then processed simultaneously upon you paying the required fees. So this is one of those very efficient processes one can do, similar to obtaining a CR12 with the Register of Companies.
And the next, we discuss about change of accounting reference. Emily?
Thank you very much, Nancy. Now I'll take us through the change in accounting reference date. This is as provided in Section 634 of the Companies Act. The Companies Act provides for restrictions as much as it allows for change in accounting reference dates, which may be done for various reasons. For example, a company may want to align its accounting reference date with the reference dates of parent organizations or holding companies, or it may just be an alternative to ensure your financial year does not end at the busy trading periods, or sometimes you may want to align your financial year with the tax end of year. Now, for you to effect this change, it is more a KRA issue than a BRS issue. The BRS function is, I understand it's majorly a notification, but you have to first clear with the Revenue Authority before you're able to notify BRS of the change. And the notification is in Form CR42. Maybe just to also mention that the period can be shortened or lengthened, but subject to the restrictions that are in the Companies Act. So after that, then we just go straight into the company records to be made available for inspection at the registered office, unless there's any question in relation to change in accounting reference dates. Now, some of the records that need to be made available is the register of members, the register of directors, and the register of directors' residential address, the register of secretaries, the register of interest in shares disclosed to public companies. You also need to keep the register of debenture holders, as well as the register of beneficial owners. In addition, our company needs to keep the director's service contracts, the director's indemnities, instruments, creating charges, and a register of the charges and debentures as well. Then you also need to be keeping records of resolutions and minutes of general meetings, as well as contracts or memorandum relating to purchase of own shares. The company is also expected to keep documents relating to redemption or purchase of own shares out of capital by a private company. So in these records, it's important for us as practitioners to differentiate which ones, these awards are available to the public, but there are also records, as we had mentioned earlier in the presentation, that are confidential information and cannot be disclosed without prior approval.
So I think just to reiterate, following the last comment by Emily, you would notice that we didn't say for inspection by the public. So the inspection here we are talking about, when we talk about register of director's residential address, the only persons who have access to this register are members of the board themselves. Register of beneficial owners, no one meetings. We have also in this segment the register, the minute book, including board resolutions and board minutes passed over time. Now, not even shareholders or third parties have access to that register. So when we talk about inspection, keep in mind that there are restrictions for each register on who can inspect that register, and only that person then has access at the registered office of the company to go through that particular record. Emily?
On the next slide, we talk about the company resolutions. So according to the Companies Act, it provides for various ways on how companies can pass resolutions. So for this applies for both public and private companies where it comes to voting at general meetings, where we have ordinary and special resolutions. So for the thresholds for ordinary resolutions, it requires a simple majority of 50% plus one vote, and for special resolution, at least 75%. However, this might change from company to company, where based on the articles of association or where the shareholders agreement have specified various ways of voting may apply, but the Companies Act remain as the ultimate guidance as to how the company pass resolutions. So there are two modes of voting: by show of hands and by poll. The other type of resolution are written resolutions, which only apply to private companies by shares. When you read through the Companies Act from section 263, however, there are restrictions or exemptions as to when you can use the written resolutions. The exemptions to these provisions is when it comes to the removal of a company auditor before the end of term, Section 739 of the Act, and the removal of director before the end of term. The removal of director was widely discussed by Emily and Malachi, where you need to serve the directors with the director removed with special notice, the age and has to meet the day for the special notice for the age. Okay, so for the resolution. Thank you. Resolution need to be notified with the registrar within 14 days of passing the resolutions, accompanied with Form CR19. If there are no further any question, I'll proceed with the change of name. For the change of name, it may be passed through a special resolution if maybe conditioned by an occurrence of an event or by any means provided by the company's articles. For the documents to be filed with the Register of Companies is a Form CR15, that's the notice of change of name, and Form CR19, which is notice of the ordinary or special resolution. For a letter of no objection applies where a company might want to modify the existing name, where maybe they're dropping a name, a word from the existing name or adding. So in this case, you write a letter to from the existing company stating that they're not objecting to the reservation of the new name, so that the new name adopts or where a company is being incorporated with which has an existing name with an affiliate where you need to use the same name. So if the affiliate business is existing and you want to change for it to maybe be a subsidiary, again, you need to prepare a letter of no objection that is signed by the officer of company, the director or the secretary. But again, from my personal experience, the registrar might request the letter to be signed by more than one officer of the company or all or just one. So it all depends. And again, all these requirements change from time to time at the discretion of the Register of Companies. When it comes to the change of constitution or the articles of association, the objects, especially for companies that were incorporated or were incorporated under CAP 486, they might, it's okay to change any objects, and these objects can only be amended by a special resolution. And when a company wants to again change the articles, it has to be amended by a special resolution where 75% of the members approve the changes. For you to change, you file with the Register of Companies a Form CR19 notification of special resolution and a copy of the articles of the objects that have been amended with the Register of Companies within 28 days. Sorry, within 14 days.
Just a general comment on this. For companies registered under the repealed act, all the objects that were under object 3 of that memorandum and articles of association are now part of the articles of association. And when you are amending them that they are now part of the articles of association. We will provide a template resolution that you can look at to guide you in this process. Now, companies registered under the Companies Act 2015, there is nothing to be amended in the memorandum and articles of association, in the memorandum of association. So the only document you can amend is the Articles of Association of the company. So for those companies that then had a lot of provisions in their memorandum, you can then opt to clean it up so that it's compliant with the template of a memorandum given under the current Companies Act, or keep at the back of your mind that any additional provisions of the memorandum as was earlier articulated under the Repealed Act now form part of the Articles of Association of the company.
We'll proceed to the share capital, and I will hand over to Malachi.
So on the share capital of the company, we have had a lot of discussions on issued capital, authorized capital, unissued capital of the company. I think the general understanding is that only what is issued to shareholders form part of the share capital of the company. If the company goes into liquidation at any point in the life of the company, if there is any portion of the issued capital that is not fully paid up, only that a call will be made on only that portion that is unpaid. So then it follows that any shares that the shareholders have not taken up or has not been allotted to them does not form part of the share capital of the company. So when we are preparing a statement of capital, it should be understood that the intent is to capture that share capital that has been taken up as fully paid up, partly paid up, or unpaid by the current. If a company wishes to increase its share capital beyond its registered nominal capital, the company is required to file a statement of increase of nominal capital from CR 19, which is the notice of special resolution, from CR 20, which is the notice of allotment, an extract of board minutes or resolution authorizing the allotment of additional share capital. Now, an increase in share capital attracts stamp duty at 1% of the portion of the increase of capital. Now, if you are making your notifications, the statement of increase of nominal share capital needs to be stamped by the Lands Office before you present it to the Registrar of Companies. Now, one of the forms that has been added in the past under this segment is Form 204, which is a form under the Repealed Act. We have discussed and we've agreed at the past JLC and technical subcommittee meeting of the JLC that that will be dropped off in the next installment of the platform. So we do expect that in due course, the only documents that will be required are the ones that we've listed here once one has paid stamp duty. I think it's important to note, members, that the statement of increase is a form under the Stamp Duty Act, and that's why we are still using the same form we were using under the Repealed Act. So take note that the statement of increase of nominal share capital is a form under the Stamp Duty Act, which is still in force. The various changes that you can do in affecting shareholding of a company that then affect the share capital of the company. The first one is allotment of shares. It should be noted that under the Companies Act 2015, the process or the procedure through which we are increasing share capital has changed from what we were used to under the Repealed Act. What now happens is through the act of allotting shares, you increase the share capital of the company. Now, for you to allot, either you need authorization or you don't. You do not need authorization by or from the shareholders where there is only one class of shares. If you have more than one class of shares, you need authorization. Now, when you are allotting shares for private companies, preemption rights applies, and you also need consent or permission from the existing members for you to allot shares. Now, once you've gone through the preliminary motions of increasing or allotting shares and you are done, you're at the tail end, the documents you need to then file to effect an allotment of shares is CR20 and CR19, where the filing involves where you need authorization from shareholders. Please do remember that in the previous slide we talked about where you are increasing the nominal capital of the company and there were no additional unissued shares in the capital of the company, you need to then file the documents that create the shares that you are allotting. And this is the statement of increase of capital. You need the form CR19 separately talking on the resolution where that is required for companies registered under the Repealed Act. You may need to amend the memorandum and articles of association to remove the clauses that restricted the share capital to a particular amount. So depending on what the status of your company is, you may need to do much more than just filing a CR20 or CR19. Now, subdivision of shares is where, for example, you have 10 shares of 100 shillings each, and you want to subdivide them to move from 10 to 100 shares. So each one share becomes 10 shares. And then the share capital in principle remains the same. You don't change. The nominal capital of the company remains the same. It's the number of issued shares and the par value which you vary, where the number of shares increases and the par value reduces. That's subdivision. In consolidation is where you have 100 shares and you want them to be 10 shares. So you are in a way consolidating a number of shares, issued shares into one share. So again, the nominal share capital remains the same. What changes is that the number of issued shares reduces while the par value of those shares increases. So subdivisions and consolidation are the opposite of each other. The documents, the preliminary steps you need to take is do the board resolution, do the board meeting recommending the change to shareholders, and then you need an EGM or AGM where the shareholders pass a special resolution agreeing to either the subdivision or consolidation of shares and reissuing of the share certificates to be passed by the directors of the company. Once you're done with that process, the documents you need to file with the registrar is from CR19, speaking to the authorization by shareholders or members of the company, and a form CR34. Once you are done with this process, you need to reissue the share certificates and update the register of members accordingly. On variation of class rights, so for example, you have ordinary A shares, ordinary B shares. You want to vary the rights of B shares so that they do not have voting rights. If they currently have, but you want to remove that right, then that's called variation of class rights. You need a resolution of the company and you need a resolution from the class whose shares are being varied to also pass a resolution to that effect. Then you file a form CR19 and a form CR33 within 14 days of the shareholders meeting where that decision was passed. New name or designation of class of shares. So this is where you have an ordinary class and you want to change it to call it Series A ordinary shares, for example, or you want to call it ordinary gold A shares or something. You're just changing the name of the class of shares without changing the underlying rights to that class. So again, you need from CR 32, and you need the consent from the shareholders of the company. Now, reduction of share capital is where you had 100 ordinary shares issued. The consideration for which these shares were issued was an asset, and that asset has been lost. Then you need to extinguish those shares because the underlying asset no longer exists, or you are reducing the share capital to distribute some of the proceeds to shareholders because those additional funds are not required. You will need a Form CR 35 and a Form CR 19 within 14 days of passing the resolution, together with a copy of the court order confirming the reduction in share capital, or for a private company only, a solvency statement signed by the directors of the company. So the solvency statement is to the effect that with the reduction being effected, the company will be able to meet its obligations as and when they fall due within the next 12-month period. Forfeiture and surrender of shares. Small distinction: forfeiture is initiated by the board of directors. A surrender of shares is initiated by a shareholder. So in forfeiture, you have partly paid shares. The board makes a call for you to pay the unpaid portion of your shares, but for some reason the shareholder is unable to pay, then the board can then pass a resolution to forfeit the shares held by that person. Now, for surrender is where someone has taken stock of their financial capability against the requirement to make further contributions to the company in relation to the unpaid portion of their shares, and they have come to the conclusion that they are not able to continue being a shareholder in that company. They can then surrender those shares to the company. Now, the requirement is for you to submit the board resolution approving the forfeiture or surrender, to provide a stamped transfer deed if these shares are moving from the person whose shares is being forfeited or surrendered to a third party. There should be a stamped share transfer deed. This is optional for PLCs, but it's mandatory for PVTs. Statutory declaration signed by a director of the company or a company secretary attesting to the particulars that ended in the forfeiture or surrender of shares. Now, you should note that in forfeiture, there are certain notices that should be issued, and you cannot really do a forfeiture if it is not provided for in your articles of association. So you need to look at your articles. It will give you how often you should do the period for the notices required, the initial call notice, the notice of forfeiture, and by when you can actually pass the resolution forfeiting those shares. So that procedure needs to be followed. Cancellation of shares by a PLC following forfeiture or surrender of shares. So for a PLC, any shares forfeited are then considered cancelled, and under section 427 of the Act, and there is guidance issued by CMA on how to go about cancellation of shares by a public limited company. So the guidance issued by CMA only relates to listed companies. Now, for shares that are forfeited by a PLC, these shares must be cancelled within 3 years or within 1 year in some cases, and capital reduced by the nominal value of the cancelled shares. Within 1 month of cancellation, delivered to the registrar from CR 38. And if reduction results in share capital falling below the authorized minimum of 6.75 million, the company must re-register as a private company. Now, it should be noted that the option of holding forfeited shares or surrendered shares is not available to a private company. So when you are forfeiting or you are surrendering shares, you need to either then proceed to the reduction of capital or transfer those shares to a third party. The easiest way out is to transfer them to someone else who is willing to take those up. There is a question from the platform.
Beatrice is asking whether you can surrender or forfeit share to a company by PVT.
As I've mentioned earlier on, you can only forfeit or surrender partly paid shares. Now, if you are surrendering for a PVT, you are surrendering for those shares to be transferred to someone else. Or this surrender process is going to initiate the cancellation, automatic reduction of share capital for that company, because you're going to cancel those shares immediately. There's no waiting period like for PLCs. So if the company itself wants to buy out shareholders, then what you are doing is not forfeiture or surrender of shares. You are doing a share buyback, which is a different process under the Companies Act, and we will look into that later on. So where the company itself is the one purchasing the shares, then it's not a forfeiture or surrender. That's a share buyback.
Thanks, Malachi. Michael is asking that he has seen instances where forfeited shares to a company are automatically deemed to have reduced the share capital. Is this proper, especially where the process started prior to the new rules? And how can a company reclaim those shares?
So when you forfeit shares, the Companies Act require you to reduce the issued share capital by the amount of the shares forfeited or surrendered. But then you need to create another account in the books of account of the company where exactly the same amount forfeited or surrendered is then credited. So in the books of account, the share redemption reserve account, in the share capital account in your books of account, I think I've said too many accounts. So you are moving the amount from issued capital, but you are credited exactly the same amount in the share redemption reserve account. So in your books of account, the share capital has not reduced. What has reduced is the issued share capital of the company. So for a PLC, for a PVT private company, because you are going to transfer the shares immediately to someone else, those transactions does not lead to a share reduction account. But where there is no one taking those shares, then you need to make the relevant entries in your books of account to ensure that your share capital is properly recorded. For a PLC, we've just outlined the approach that needs to be taken.
Thanks, Malachi. There's one more, that there are instances where a shareholder exits the company and they're being non-willing to purchase the shares. Do they revert back to the company to be transferred at a future date when a purchaser is identified?
Shares held in a company are private property. You cannot transfer someone's shares unless you go through the outlined processes under the Act. So if I'm holding my shares and I have fully paid for them, there's not much the company can do in respect to those shares unless the shareholder and the company agrees to undergo the share buyback process. But the mere fact that someone has exited the company, and by using the word exit the company, you are a member for as long as you are holding shares. Now, if other members don't like your face or don't want to deal with you or something like that, that's one thing. But you cannot just exit because you can no longer be traced. Now, any provisions in the articles of association of the company that deals in the shares of members that cannot be traced are null and void. to the extent of the law. So where you are talking about a shareholder having exited, you should be very careful then how you deal with those shares, especially where those shares are fully paid up. If they are partly paid up, then the company can initiate the forfeiture process, in which case then the shareholder loses. But where they are fully paid up and you cannot trace that shareholder to sign a memorandum for the share buyback, there's not much, in my view, that you can do in respect of those shares. How do we transfer surrendered shares? According to the board resolution, if the shareholder is willingly surrendering the shares, the shareholder can sign the share transfer form, or the board can appoint one among them to execute the transfer documentation with the transferee. So the transferor can be the person transferring themselves through the surrender process, or the board can appoint one of the board members or the company secretary, for that matter, if you are brave enough for you to sign the required documentation. Can we take about 10 minutes break between now and 11:15 as we think about what we've shared for the past 1.5 hours or so? And you can formulate new questions, and then we start the next segment when we return. As we resume, just to reiterate the housekeeping issues, for those who are members of ICS, CPDs will be issued for this session. Please do leave your full name and ICS number under chat. We'll put this together and share them with ICS for you to get the CPD points. Again, for those who are for some reason could get unmuted, please do keep yourself muted so that we do not get a lot of interruptions during the process. To continue from where we left, still on changes affecting shareholding of a company, purchase of own shares. This is the share buyback process initiated by the board, approved by shareholders at a general meeting. You need to file a form CR37 within 14 days from when the purchase is approved by the shareholders, or within 28 days with respect to an immediate cancellation. This is for private companies. Now, where a private company purchases its own shares, it cancels all the shares so purchased. And a public company can retain up to equivalent of 10% of the issued shares as treasury shares. For a public company, what this means is that you are going to enter the company in its own register of members as a shareholder of itself. Under the Repealed Act, this was illegal. So we have shared separate documentation that can guide you on the process of share buybacks, and we will highlight those in the next segment when we go through the templates we've prepared for you. On transfer of shares, you need to prepare a Form D. You need the company's auditors to prepare Form D. The share transfer form will need to be assessed and stamp duty paid, and board resolutions and extract approving the transfer of shares. Now, in some instances, the transfer of shares can be achieved fully online by doing the resignation of a shareholder process, and then you upload the full particulars of the transferee in the system. If the transferee is an existing officer of the company, then the last portion may not be required. Transmission of shares happens in two scenarios in your companies, where a shareholder has died and a certificate of confirmation of grant has been provided. The shares can be transmitted to the beneficiaries, or they can be transmitted to the administrator. That's the first instance. The second instance is where there are joint shareholders and one of the joint shareholders passes away. Then the shares need to be transmitted to the surviving joint shareholder or joint shareholders. This will be subject to whether there were any shareholders agreement between the two, or there are other agreements that would determine whether the transmission will happen or not. So where there is a transmission of shares in the first instance, you need a copy of the certificate of confirmation of grant together with the schedule to it, a copy of the death certificate, duly executed share transfer form. This is optional and it only applies where the transfer is to a third party. And of course, a board resolution confirming the transmission of shares. In the second instance, you do not require certificate of confirmation of grant. What you need to provide is a copy of the death certificate, the transmission notice by the shareholder, and the board resolution confirming the transmission of shares. Now, if there is no transfer to a third party, the transfer form is not required in this process. Now, these processes are agreed as they are, but they are not in the practice note. That's why we've highlighted them in red. And we will address this when we discuss the amendments to the practice note number 3.
And take up the conversions. The Companies Act, these are the conversions provided for the private company to public company to a private company, private limited company. There is also a public company to a private and limited company, a private company to a private and limited company, and lastly, private and limited company to a private limited company. We'll not dwell much on this because there is a separate practice note which will be changed in the near future. But worthwhile noting is the private company conversion to public and the public to private limited company are available through the manual portal. The next one, charges will be covered by Emily.
Thank you, Nancy. Neles, can you now hear me well? I've just noted your comment that the volume is very low. So I'll take us through the registration of charges under the Companies Act and the forms that you need to file with the registry. So for when you create a charge, you need to file form CR25, which is the particulars of the charge created. And this is for a company that is registered in Kenya. And this needs to be done within 30 days of creating the charge. And the form CR25 is to be accompanied by the charge itself or any other instrument creating or evidencing the charge. Now, when you create a charge subject to which property or undertaking has been acquired, now that's form CR26, which also needs to be filed within 30 days. And it should be accompanied by a certified copy of the instrument creating or evidencing the charge. Additionally, there's also CR27. That's the particulars of a charge subject to secure a series of debentures. Still needs to be filed within 30 days, and it should be accompanied by the deed containing the charge or one of the debentures of the series of debentures. Then finally, CR28 is a memorandum statement of satisfaction in full or partial satisfaction of a charge. So once you have satisfied your obligations under a charge or a debenture and you get a discharge, then you need to file CR28. There is no prescribed period. So the 30-day time limit does not apply. And that form may be used for either a partial discharge or a full discharge. So if you're not able to file your CR25, 26, and 27 within the 30 days, for whatever reason, then you should obtain a court order for the registrar to actually accept your filing as provided in section 888 of the Companies Act. Unless there are any questions, I think that's it for the registration of charges.
Now, we were taking questions as we were going along. I don't know whether there is any member who feels their question is too long to be typed in the chat. Please raise your hand or just unmute yourself and ask your question before we go to the next segment, which is the templates. So may I request any member who has a question they want to ask, please unmute yourself and ask your question. I'm seeing Grace Muriagoro has unmuted herself. Grace, you want to ask a question?
Yes, thank you very much. I appreciate the presentation which has gone through today. It makes a lot of clarifications. Thank you for your time. On the appointment of a receiver, the old act had stated that once a receiver is appointed, the very act of appointment causes the whole board to cease operations. And the company secretary was part of that board. But you mentioned that a company secretary can continue working with the receiver. I needed that clarification. That's number one. Number two, what is the position of unissued shares in respect of companies which were registered prior to the new act? Thank you.
Any other question? We can take about 3 questions from 3 participants, then we answer them together.
Hello.
Yes, Michael.
I have a question. In certain instances, you might find that this is under the registration of charges. You might find that you're acting for a client who's not a financial institution as such, but they are authorized to lend by the, let's say if it's a government parastatal, so they're authorized to lend under the particular act. So if we have had a challenge in the recently when we tried to register a debenture, and we were informed that that parastatal needed to be registered at BRS, yet it's a government entity. So we were just wondering how to go about that.
That's noted. David Seaman, you have a question?
Yes, hi, you can hear me?
Clearly.
My question was actually posted on the chat, and it mainly related to instances where articles of association of a company requires a unanimous vote. Let's say, for example, in matters of disposal of company's property, and my client here cannot really secure the unanimous vote. So what it kind of brings the parties to a kind of deadlock where they can't transact because the party X want this, but this party Y can't agree. I must say that the articles may have been badly drafted, but that's the situation where one find themselves. What is your advice on the way out? And you've tried mediation, it's not forthcoming. So what will you advise as the way out in such a scenario? Thank you.
Okay, thank you, David. Starting with the question from Grace Mulyagoro, two questions actually. My comment was that when a receiver is appointed, it does not remove the officers as at the date of appointment from office. It's just their powers are seized. So they cannot pass resolution as directors, they cannot make new appointments, they cannot make changes, they cannot transact the business of the company, but they still remain directors. For example, if the company is turned around and the receivership period ends and the receiver is going out, it is the directors, unless there is a contrary court order to that effect, the directors that were there at the point of the company going into the receivership are the ones that then continue to be directors after the receivership period ends. If the company is being wound up, it will be wound up with those individuals as the last directors of that company. So my comment is to the effect that, yes, you do not have powers to exercise your rights or duties or responsibilities as directors, but on the records, in the register of members, you are still directors during the period of receivership. And if the receiver has any questions, you are the ones to answer those questions as directors of the company. So I don't know if that clarifies, but you do not go home relieved of your duties and the register of members updated and you are updated by removing it, but you do continue during that period. Now, on the issue of unissued shares, prior to the new act, the registrar has agreed that these shares will still continue being available to the company for allotment. So there are two schools of thought when we apply section 14 of the act. One school of thought is that the unissued share capital, companies being registered under Companies Act 2015 cannot be registered with unissued shares, whereas the other school of thought is they can. Now, the registrar is still allowing both scenarios to happen today. But the argument we are making here is that any shares which are unissued does not form part of the share capital of the company, because only that which is issued is share capital. Now, if you have unissued shares, you can wait and allot them next year, you can allot them now, you can allot them as and when you deem necessary, because in the Companies Act 2015, there are no saving clauses for them, and an administrative decision is yet to be taken. So for the time being, you can allot them as and when your company is ready. If we get to a point when the registrar takes a decision on any unissued shares for all companies generally, then we'll have a better position to discuss on what to do next. On the question of raised by Michael on the acting for a parastatal, my general understanding is that this parastatal is not registered under the Companies Act. So why are you making a notification to the registrar of companies in the first place? So I think when the registrar tells you that your company needs to be registered, I think the general indication is that the registrar of companies only takes notifications for companies that are registered under the Companies Act. Companies registered under different legislations are not within the ambit of the company's registry. So I think you might need to look at that. If the notifier is the parastatal, then they are not subject to the requirements of the Companies Act. So you might need to address that. Emily, do you have any comments on this? And we are happy that we have Zakaria here, or Karen. Is this, Shigadi is also somewhere? If you can chime in on this one, starting with Emily.
Thank you, Malakai. I have no further comments. I agree with your sentiments.
If Shigadi is on the call.
Malaka, I think you've covered all the questions were asked. I think on my end, I would not have anything to add.
On the question from David on articles requiring a unanimous vote. Now, basically, you shot yourselves in the foot because the Act does provide the minimum, but where the articles, what the articles cannot do is to provide a threshold below what the Act requires. But it is allowed for the Articles of Association to require a much higher threshold. So, for example, you can have in your articles that holding of general meetings require more than 28 days. You can have 25, 30, even 100 days if you so wish. But once you've set that threshold, it's binding to you. On voting requirements, if you in your articles or your shareholders agreement set a certain threshold which is higher than the minimum requirement of the Companies Act, then it is binding to you. And for you to get out of it, unfortunately, you selected, you elected to go with 100%. You cannot pass any of those reserved matters unless you have unanimity among the shareholder. So the only solution really for you is to see how you can amend your articles to have it adopting the minimum requirements provided in the Companies Act. So I don't know if anyone here can think a solution for you, but in my view, because the Articles of Association requires 100%, for you to pass those decisions, you need 100%. If you don't get it, that decision is defeated. You move to the next thing. If there's any member who has a contrary view, please feel free to chime in.
Malaka, if I could, it is not a contrary opinion. I think it is just an addition. I think the question was in relation to dealing with assets, which I think I would understand why the threshold would be raised, because disposal of assets of the company would also be a sensitive issue. And therefore, if you cannot agree, then basically the motion is defeated. And unless the articles are amended to provide for a lower threshold, but a threshold that is not lower than that which is provided in the Companies Act, then that would be one avenue. Although now the problem is if you're not able to bring both parties to the table, then I don't think it will be also possible to amend the articles of the company. But that would be another avenue to try and at least amend the articles, or maybe adopt the model articles, which would be easier to navigate.
Probably thinking out aloud, if the shareholders have reached an impasse, are they two shareholders or no? And if there are two shareholders, there is an avenue available to you where you can petition the court to give an order to wind up the company, now that the shareholders have reached an impasse and no decisions cannot be made. So that this will be the most extreme available route to you. If the business of the company cannot be conducted and the company is realizing losses year after year because of that fact, you can petition one of the shareholders can petition the court to give an order for the winding up of the company. And once you have that, then I think that shareholder will have to come to the table to see if you can salvage anything for the company. And that's the most extreme. I don't know anything not extreme in the case where there is an impasse among two shareholders on the running of a company. Any other questions? There's a question from Grace. Can you file director resignation on the manual portal? No. Resignations are filed on the live portal of the BRS. Ken Martin is recommending mediation with different parties to try and address the impasse. So you are saying the first, if you didn't work with the first set of mediators, try another set. Moving to the next segment, now that I'm not seeing any member with a question, we have prepared a number of templates. So we'll take you through the templates, and then after that, take you through the amended advertisement. We will share these links with you, so don't fret, don't start writing very fast to capture them. You will get these links together with the PowerPoint presentation after this. Everyone who attended this will receive these documents. So starting, we will go chapter by chapter for the practice notes, for the templates, and then take you in a very high level what is covered in each document. So as you would recall, the practice note is arranged in chapters, and we've named the documents according to the chapter where they are found. So chapter 1 is annual return. So the document we call chapter 1 template annual return then is you can easily cross-reference and see what document relates to which chapter of the practice notes. So we'll start with the annual return. I will highlight a few issues. For those who have annual returns that are not formatted, we encourage you to pick this Word document and adapt it as your own, so that there is some uniformity in the practice. I have seen some annual returns where you are even struggling to find some of the information because it is buried among some of the footnotes, which are now part of the main document. So we urge you, if the 150 members attending this meeting agree to adopt this template, we will have a better output, I believe. And do share, feel free to share with anyone you know who has a funny looking annual return. No pun intended. So if you look at the page 1 of the annual return, we had a few discussions. If you can just share that on the screen. Do you think there's a problem shared in the so if you look at the annual return, we are sharing with you the company number, no comment. Company name in full, no comment. If you have a business name under which the company is trading, for example, if the company name is KFC, but it's Kenya Food Chicken, so you'll say company name in full, you write the registered name of the company, and then the business name under which the company is trading and is known. You then put that under the second row. Return date is the anniversary date of incorporation for all companies registered under the Companies Act 2015. For companies registered under the Repealed Act, it's the date of the previous return. The Companies Act came into force in 2015. So the date of the annual return filed for the company in 2014 or in early 2015, prior to the act coming into force, will be the anniversary date, will be the return date to be put here. Now, the date of this return is the date that this return is made up to, which cannot be later than the return date. It can be on the date of the return date. So you can have the same date in these two categories. But the date of this return can also be 28 days, not more than 28 days from the return date. So for those companies that have 31st December as their return date, you can prepare this return, and the return date will be 31st December 2021. At the date of this return, you can, for example, prepare it on the 15th or on the 3rd of December and send it out for your clients. And then when it comes back to you, ideally before 31st of December, then you file your return within the calendar year, as opposed to waiting until next year and file it in the new year. The way the system is currently configured, if you file it on the 1st of January, you incur the penalty for late filing. So I do hope that the two dates are clarified. The third date that I would want to then clarify is the date under part 9, which is the date that the return is signed. Part 9 under signature, you put the name of the director, the address, they sign, they put the capacity, and then the date of signing. The only people who can sign this document is a director or a company secretary. Now, the signing date can be later than the return date. If you are doing the automated return, this date will be the date that you downloaded the return. So please take note. There is another issue in the system when you download the automated return, is that it gives you 28 days, but in those 28 days, it does not include the return date. So this date can only be earlier. We've raised this with the developer, and hopefully in the next update of the system, you will find that you can have the same date appearing here. Then the date under part 9 will be the date that you downloaded the annual return. All the other issues, I'm sure members should be able to feel comfortably. The other area I needed to talk about is the statement of capital. Now, in the statement of capital, the position I am taking as a practitioner is that a statement of capital should only reflect shares that have been taken up by shareholders. Any shares that have not been allotted or issued to members should not be reflected in the statement of capital. So if you have a company, for example, that had an authorized capital of 1,000 shares of 100 shillings each, that's 100,000, but only issued 2 shares, the share capital of that company is 200 shillings for all purposes and intent. So only information we put there is that the class of shares is ordinary, the nominal value is 100, amount paid could be 100 or less, amount unpaid could be 100 or less. Total number of shares then is only 2. The other 998 shares are not allotted to anyone, and to that effect, they are not share capital of the company. So the amount then that shows here as the total is the aggregate total of the shares that are issued in the company. We've discussed this variously, and at the JLC, we are in agreement that the share capital is that which is issued to the shareholder as at the date of this return. I think the other issues here are straightforward, and any member who has a question, we are happy to meet you at the next JLC meeting and address those questions.
I'll take us through the chapter 2 and I'll highlight a few of the items. So the first would be, let me just show my screen. I'll take us through the special notice for the removal of a director. So the special notice is a letter from the members of the company to the directors of the company, notifying them that they plan to remove a director based on reasons. For instance, a company might have in the articles where maybe the director has not appeared in a board meeting or attended a board meeting for three consecutive board meetings. In such an instance, that will be the reason for the removal of a director, or if that person has contravened any rules of the company, or the reasons might vary from one company to another. So once the directors are in receipt of this, the person authorized to carry out the removal, for example, the company secretary might now require to post this special notice to the director in question. And the ways of service is through a postal address registered with the register of companies, an email address which is also registered with the register of companies, or the company might also do through like a newspaper with a wide coverage for 14 days. Once this is posted, you'll also need to prepare a notice and AGM. I'll just try and retrieve the notice, but the notice is the standard that is used in any AGM or any extraordinary notice of a company. The other that I would like to highlight among the templates would be on the retirement. This is a form CR19. You don't need to file the minutes. You can only file the CR19 together with the CR auto-generated on the system. So in this CR19, you just note that this particular director is retiring by rotation, and you can quote the article in the articles of association that provides that this particular director is retiring by rotation, so that it's very clear and it's not confused where the person is leaving and it's a resignation or by rotation or retirement. So the other documents we have under this template include the contractor's director, notice of residential address, how it should look like. The other document, the other templates we have still under chapter 2, it's the letter of consent to act as the company secretary. Chapter 3 covers the change of registered address. This is a board resolution that can be adopted when doing a change. Chapter 4 covers the change of accounting reference date. This is a board resolution. We also included Form CR42 that can be modified based on the company. For the items, chapter 5, 6, those ones we don't have templates because the 5 covers records, this covers resolutions, which resolutions also adjust ordinary minutes or written resolutions. Then we go to chapter 7. This is the change of name. We have an extract of minutes template. Then we have form CR15. We also have a form CR19. Under chapter 8, this is the change of constitution. We have a CR19 on what should be indicated. We move to chapter 9, where it's the shareholder, the alteration of share capital. Under this, we have a CR19 on the reduction of capital. We have a statement of capital with respect to the reduction of share capital, that's form CR35. For the cancellation of shares by a PLC, we have a sample extract of minutes. For forfeiture of shares, we have a board resolution template. We also have a statutory of a director of the company secretary confirming the surrender or the forfeiture of shares. For the surrender of shares as well, we have a board resolution template. The notice of purchase of shares form CR37. Purchase of own shares by the company form CR37. A sample minutes for the same. Return of shares. We also have an increase of nominal capital from CR19 template. Statement of increase of nominal capital. We have a return on allotment from CR20. This sometimes the system is able to generate the information being filed, but sometimes the system does not auto-populate.
So the system auto-populates the form if you are allotting shares to existing shareholders of the company. You can download a completely filled form, you just sign and upload back. Where you are allotting shares to new people being added as shareholders, the system will give you a blank form, in which case you need to fill a manual form, sign and upload in the system. I think those are the scenarios where you get or you don't get the auto-generated form.
Then there's notice of subdivision of consolidation of shares. Here, when someone is filing, will file what's applicable because the form provides for both the subdivision and consolidation. That's from CR34. We have a subdivision or consolidation of shares from CR19. Then we have a notice of particulars of variation of rights attached to shares. That's from 33. And also from CR19 on how you can put the content in that from CR19. Then change of name. or other designation of class of shares, Form CR 19, and also the Form CR 32, which is the form used to give notice to the Register of Companies. Lastly, under that chapter, we have the notice of cancellation of shares or purchase shares from CR 34. Then chapter 10 covers the re-registration, which is a separate practice note. We don't have templates under this. Those ones will be provided in the other practice note. Then under chapter 11 on charges, we have Form CR 25, which is used to notify the company where a charge has been created by a company. Form CR 28, when you're notifying the Register of Company for the moment when you are discharging that particular charge having been paid. And then we have also a sample board resolution approving the creation of a debenture by the company, or notifying the Register of Companies that a certain charge has been discharged. And then for, as you recall, under alteration of share capital, we also talked about the transfer of shares which had not been included in the current practice note. We included a form D that is used for the stamp duty assessment. We also have a sample share transfer form and a board resolution also for a transfer of shares. That covers this practice. This link will be valid for the next 2 weeks until 27th July. The password to access this link is the same as the password for this meeting, which is training07 with TR in caps. So feel free to download these templates and adopt them as you wish within the 2 weeks. Thank you.
So before someone asks, where is the link? The link is now on the chat. The purpose of sharing this document is to help each other get certain documents that you may not have good templates prepared. And as Nancy has mentioned, these documents have been prepared by the team, and we are happy to have them available to you for the next 2 weeks. It's password protected. If you joined this meeting, then you know the passcode for the meeting. The passcode for the meeting is the password. So please do the necessary, hopefully after the meeting, not right now. We still need your attention. So just copy the link somewhere and keep it safe for use after the meeting. Having said that, I'm going to take you through the next segment of the presentation. We are doing very well time-wise. You can see my screen on the amended practice note number 3. So the first thing we are just doing is to just format the document so that it looks better. So I will not dwell much on the formatting. I'll go to the substantive changes. So under chapter 2, we are proposing to add secretaries and auditors as event-driven changes that need to be covered under this practice note. So there is no proposed change on introduction, just formatting issues. On chapter 1, we are clarifying the Companies Act is number 17 of 2015, and then going forward, any reference to the Companies Act is going to be CA 2015. On the date of this return, we are clarifying that the date of return should not be later than the return date and not earlier than 28 days from the return date. So just to bring clarity on that date, what can be done. This is aligned with the footnotes in the prescribed from CR 29. And a statement of capital, we are clarifying that the statement of capital should reflect the sum of the nominal value of each class of shares issued to the current shareholders. Now, for those people who are commenting on the chart that the registry, there are instances where the registry asks for the statement of capital to include the unissued shares. I think this is just an issue we need to clarify with those specific staff members, because it has been generally agreed and adopted by and signed off by the registrar that the position we are presenting at this session should be the position for the statement of capital. So where there are some issues with registry staff, we are happy to pick this, and this is specifically why the JLC exists, so that issues that deviates from what is agreed position are then clarified and a common position adopted going forward. So now that Karen and Zakaria are here, I do hope that that comment of statement of capital is going to be communicated to their staff members going forward. Myself, I've received those corrections in the past. On chapter 2, because we are proposing to add secretaries and auditors under chapter 2. And on that paragraph, we are proposing that the company must then file the appropriate prescribed form and supporting documents with the company's registry within 14 days. So it's not enough just to sign, to file the form. You also need to file supporting documentation with that notification. Under the resignation from office, there has been queries whether this statutory declaration can be signed by someone else. And we are just adding a line that the signatory should be the resigning director. You can't get, the secretary should not sign, the chairman should not sign, a shareholder should not sign. It's that resigning director who needs to sign. So this amendment really is being introduced because of members asking, but it's a statutory declaration, it's signed, it's confirming the director is resigning. So this clarifies further. On the removal of the director, we've added a few clarification points. The proof of service of notice and agenda for general meeting needs to be. So the agenda should show that there is a removal of a director to be discussed and considered at that general meeting. It's not enough to just say notice is hereby given that a meeting will be held on the 28th of July. Yes, that's a notice, but what is of interest for that meeting is the agenda item for the removal of the director. And it should invite, there should also be invitation to the concerned director to attend the general meeting. From CR 19 containing extract of minutes confirming quorum and resolution approving the removal. So in the past we've been asked who attended this meeting. So where we are doing CR 19, we don't need to include the list of attendees, but it's then useful to confirm that there was quorum and also include the resolution itself in the Form CR 19. For rotation of directors, the Form CR 19 should include the decision not to re-elect the director. You see, when you are retiring by rotation, either you are stepping down willingly or you are not re-elected. So that needs to be indicated in the Form CR 19 that you will be filing. There is an interesting amendment that we are proposing for consideration by the registrar. It's not yet considered, but it might be useful. It is true that when a director dies, the requirement is for you to then file a copy of the death certificate. Now, the question we are posing to the registry is that we do have genuine cases where a death certificate cannot be obtained. Then there should be some trust relationship between the registrar and the named company secretary, where if you can swear an affidavit to the fact that it is known to the company that so and so died, but the company is unable to obtain a copy of the death certificate, then the company should be allowed to notify the changes. So this is a proposal. It's not yet been confirmed. It's for your information. For insanity, there should be a report issued under the Mental Health Act in respect of the affected director. So this has to be very specific to the person who is ceasing to be a director. If we go down, we have added a letter of consent to act as a secretary. Please note that the letter of consent under appointment of company secretary needs to be in writing. It's not by signing the form that you consented. That should not suffice. There should be a separate written consent. And the consent should speak to we as a firm, or I and so and so, I have consented to act as the company secretary for ABC Limited, something like that. We are adding a segment on appointment of an authorized person. The authorized person can only be appointed by the board of directors. So the documents we are outlining is the extract from the board meeting appointing the authorized person, and a letter of consent to act as an authorized person. If someone is ceasing to be an authorized person, then you need an extract from the board resolution revoking the appointment of the authorized person. For changes in shareholders, allotment of new shares, we've outlined the documents that are required. We are outlining the documents required for a transfer of shares, and we are outlining transmission of shares. Appointment of a member, this only applies to companies limited by guarantee. Members are appointed by the board of directors, and the documentation then that is required is the extract, signed statement of guarantee, and prescribed particulars of the member. Now, this appointment is being done online, but the statement of guarantee in the next installment of the amended program, we do hope there will be a section where this can be attached. We have not come up with a template because we do expect that there is something to be considered in the amended prescribed forms to include this statement of guarantee, which then can be adapted for use by members going forward. So please do note that there is no prescribed form for filing this change, but it has been discussed under the business process reengineering by the registrar. Now, cessation of a member, CLG only, again, same considerations, and again, there's no prescribed form for filing this change. For beneficial owner information, this is a new development. We've discussed this at length in our previous trainings. We are setting out the forms that require to be prepared. Now, it's important to note, members, that the Form BOF1 is not the required register of beneficial owners, which is supposed to be prepared by the company, and within 30 days of its preparation, then Form BOF1 to be filed in the register of companies. We have separately shared a proposed template for you to consider and to adopt for your use as the register of beneficial owners. Please take note that those two documents are separate. You need a register of beneficial owners, same way you need a register of members, a register of directors to be maintained by the company. And when there's a change in those registers, then a notification to be made with the register of companies. So the notification in the case of beneficial owners that then you need to make is the Form BOF1, Form BOF2, or Form BOF3. For further information, on increase of share capital, changes in shareholding, and the additional documents that may apply for this segment. Under 1.5, we are adding removal or resignation of an auditor, which is not included in the current practice note, and appointment. Removal of an auditor is done through a shareholders meeting, and the requirement for special notice do apply. So then you will need a CR 19. From CR 43, which covers notice of resignation. So there is a prescribed form for resignation, but there is no prescribed form for appointment. So again, we raised this with the BRS. There is need to amend the regulations to provide for this, and then at that point we will be able to then indicate the form, prescribed form for the appointment of auditors. Under the difference between a service address and the usual residential address, we are adding a note. Remember from the presentation, we indicated that where the two documents where the form CR6, the notification of appointment of a director, has the service address reflecting the residential address, then the registrar needs to redact this from the public register. So that those who go to obtain CR12s or those who are doing manual searches then do not have access to this restricted information. So this is a polite nudge to the registry that there is need to check the registers where residential address has been given. This should not appear in the public register. We are proposing some amendments on the register of directors and register of residential address not being available to the general public. A slight change, particulars of shareholder. There is a gap because it doesn't address the members of a CLG. So this introduction is to cover them also in the practice notes as it is. Going to chapter 3, under accounting reference date, we are adding a line just to remind members of the provisions of the Act that you can only do a change in accounting reference date once in every 5 years. If you want to do it sooner, then you need a waiver from the Cabinet Secretary. For the purpose of the Companies Act, the Cabinet Secretary refers to the Attorney General. And you can't do it in the past. You can't say we are changing the accounting reference date with effect from to be 31st December 2020. You can only do it presently. You can't do retroactively. So that's a restriction in the Companies Act. So on chapter 5, just clarifying who need to make records available, and that is the duty of the officers of the company. For avoidance of doubt, the officers of the company refers to the directors and the company secretary. We are adding a segment highlighting other registers to be maintained by the company, which are key for this segment. We are also highlighting that these two registers are not open to the general public. In chapter 6, resolutions. In questions have been asked, what ordinary resolutions should be filed with the Register of Companies? If we hold an AGM and consider accounts and we do rotation of directors and they are re-elected, all of them, there is no cessation of office. Do we need to notify the register of those changes? So the general amendment we are proposing is that ordinary or special resolutions, other than those passed as an ordinary business at an annual general meeting of the company, have to be filed with the register from CR 19. So if you approve financial statement through an ordinary resolution, there's no need to file CR19 with the registrar. Or if you reappoint the auditors, there's no need to notify the registrar unless if there is a specific change happening or being approved, then you need. But if it's just a continuation of the ordinary business, then there's no need to file CR19. Our companies pass resolutions. We are adding some clarifying the statement and making, when we talk about 75% of members passing a special resolution, we do not mean 75% of the global membership. We mean 75% of those members present and voting at the general meeting or annual general meeting. So if you have 2 members and one of them has 80% of the shares and 2 of them are in the meeting, even if what we need is the percentage of the voting itself, so that that 1 member or 2 members or 3 members holding more than 75%, they have to be present and voting. If you have 4 members holding 50% and they meet quorum, for purposes of the voting, it is 75% of those 50% voting is what you need to pass a special resolution. So that's what we are trying to, the amendment we are trying to introduce under how companies pass the resolutions under this amendment. So the resolutions need to be passed at a duly convened and constituted general meeting. If there is fault, if there's default in the manner in which you convened the meeting, and the manner in which the meeting was constituted, even if you purport to pass those resolutions, they can't be implemented. So please be careful when you guide your clients in convening and confirming whether there is quorum or not. Now, we are adding, following the amendment of the Companies Act, that the meeting may be a physical meeting, it may be a virtual meeting, or a hybrid meeting. So there is no need to then stick to the earlier position that all meetings must be physical for that case. Now, for under Chapter 7, change of name, on notification, we are clarifying that the company must notify the registrar of a change of name by submitting a notice of change of name from CR19, which is the special resolution, and a letter of no objection, which is optional, depending on whether that name is similar or the same as an existing name in any of the registers. The general rule is that the registrar shall not accept any name which is similar to another name, and that other name need not be on the company's register alone. It could be on the LLP, could be on BN, it could be on partnership registers, provided there is a register maintained by the register of companies where that name appears, then you cannot use it. Under Chapter 8, we are clarifying the company's articles of association, which after this we are using the word articles to mean articles of association for clarity. Under share capital, we discussed this at length. The nominal capital of the initial subscribed shares is the share capital of the company. So again, we are clarifying what is the share capital of the company. I do hope that this issue will be put to rest soon, so that we have a common understanding rather than having 2 schools of thoughts that we have now. Now, if you incorporate a company and end up with an issued shares in your documentation, any unissued shares then do not form part of the capital of the company. And it makes it very difficult when you come to completing the statement of capital. Now, for the sake of convenience, some members are of the view that they need the unissued shares when they form the company, whereas some members are that this is necessary. So we will need this to be clarified in the regulations so that there is no dual interpretation of the provisions of the Act and the regulations of this matter. But we are proposing an amendment to the practice of that the nominal value of the initial subscribed shares is the share capital of the company for to clarify this position. You will not believe how many calls or questions come up on this matter alone. So that may be necessary. We are doing a few cleanup amendments just to clarify further. So we're not going into those. Statement of capital, major changes, allotment of shares, changes, variation of class rate, no major changes. The new name or designation of class of shares, we are just adding a statement to join the two statements. Reduction of share capital. We are clarifying that the solvency statement only applies to private companies and not public companies. Forfeiture of shares, very minor changes. Now there is a explanatory note at the end of that we are proposing that in the case of a public company, any forfeited or surrendered shares which are not transferred to a third party within 3 years of the forfeiture or surrender are being cancelled. So in our main presentation segment, we did clarify what happens what needs to be filed to achieve this position. For private companies, they don't have this 3 years period. There's the cancellation takes effect immediately if those shares are not transferred at forfeiture. Then cancellation of shares by a PLC, again, some clarifying on the threshold that a public company can hold as treasury shares. Under Chapter 10, minor changes. So we do hope that with these amendments, which will be version 2 of the practice notes, we will get comments, and then this comment will be tabled with the registrar of companies. They will make their further comments, and then once we are in agreement, the amended document will be tabled at future GLC meeting for it to be adopted as the current practices. Now we are sharing the link to this document. Yes. The further charge, the first borrower is signing the further charge is the owner of the property and not the borrower. I've just posted this under chat. Please, this is the link to the Word version on a share drive. Please go through the recommended changes. If you have any contrary views or you have further changes you feel we've not covered in our proposed amendments to version 2 of the practice note, please feel free to share those. We will table this at the next technical subcommittee, then to BRS team, then we will consider it under future GLC meeting for adoption. But your input as practitioners will be invaluable in having a document that speaks to the practice in all its various aspects. So please, we do request you put in a few hours and go through this and let us have the feedback in due course. With those few points, we are at the tail end of the presentation for today. We still have 30 minutes to spare. If there are any questions or comments or any areas that participants today want to highlight, please feel free to do it now. If you don't want to give comments, I'll go through the list and pick one member at random. I hope that's a good enough thread for those who want to join. On the comment on the practice notes, Karen, if you're still with us, maybe you can just give some general comments if you have any, or is that Karen?
Malachi, maybe just to mention that it is a good thing that you've embarked on the process of amending the practice note, because of course we realize that some of the issues that we considered in the practice note are not properly covered, or we have quite a number of issues which are still not covered under the current practice note. Therefore, I've seen some additions, including the introduction of the shareholders, notification of change of information of the shareholders or members, which is a good thing. I think we've had quite a struggle in trying to come up with a way of ensuring that at least if there is change of information, we are able to capture the same. And you remember that we do not have a statutory form for that. So I think it is a good step, and I think it will help us in trying to make sure that we are able to capture all the information that is notified to us by the various stakeholders in terms of keeping an up-to-date record of the register. So it's a good move.
Thank you for those comments, Akaria. A member sent me a private chat that where is Simon today? I think it's about time Simon now speaks up.
I am very much on, Malachi. Good afternoon, everyone. I'm in the back banners today, letting Malachi and team just go ahead. But I'm here. Thank you for the good work, Malachi. And I think it's important what you have said, that we need to actually, as practitioners, just go through that practice note and see if we have any improvements we need to make on it. I'm happy that we've got members of BRS, and so some of the feedback we've been getting on corrections around trivial things like share capital. I hope that on the annual return, I hope that can change starting today. So Karen and team, that's just a call to you guys. But thank you for a very good session this morning.
I'm sure a few members are now smiling. I've seen you at last.
Thank you, Malachi.
I'm seeing Virginia Ndunge is on the call. Virginia, want to say something? And Robert Ndumu. I said, if you're not talking, I'm going randomly through the chat to call out members who can make a few comments.
Sorry, Malachi, how are you?
Very well today, Virginia.
Yeah, mine is just to commend you for the good job that you're doing. We are really grateful and we appreciate what you're doing. But allow me to digress a bit. BRS has become quite slow in terms of giving approvals for changes and linking, and we're wondering whether you can intervene and do something about it, because it's quite frustrating, and especially for our clients. They think we are not doing our job.
Thank you for confirming that this is a digress from the main discussion today. So my digressing comment is that this is being considered, and if you remember the last JLC, the registrar did confirm that they are looking at strengthening the capacity to add additional.
Thank you. Thank you.
Staff to affect this. So it is a matter we are already following up. We are all aware that government procurement does not happen overnight. It takes a process. So ours is just to follow up and see if it can be done as soon as possible. But it's a matter that is the registrar of companies, and indeed the top leadership, starting with the board of BRS, is alive too.
Thank you. Thank you, Malachi.
Francis Muya.
Hi, Malachi, you called me out. My name is Robert.
Yes.
Yes, thank you very much. I think that was a good presentation, and I think it's helping us guide us practitioners, and especially the upcoming ones who are yet to who are still learning. So thank you very much for your contribution. I think mine is just to echo Virginia's observations on the speed of transactions. It's getting a bit worrying, and sometimes I'm almost for dodging clients' calls now. So I think we've had you, and we shall continue explaining to our clients what is happening. Other than that, thank you.
Thank you. Annette Muriuki.
Hi, Malakai, and thank you very much. That was a very, very good session, very practical too. We learn a lot, especially from the questions asked and the responses, as well as the content for the session. So we really appreciate. Thank you.
Wendy. I'm calling Wendy from the SCARE Nairobi office for avoidance of doubt.
On behalf of Wendy and team, we'd just like to thank you for the cooperation and the well-presented points. We also like to just encourage members and all advocates to share their opinions with Malakai and team. Maybe they'll be able to forward them to us as well, so we can collaborate with BRS to make the necessary improvements and changes. So thank you, Malakai and team. Have a lovely day.
Thank you for those comments. I think just to reiterate, this presentation is a collaboration between BRS, between ICS and LSK Nairobi branch. This presentation had already been made to the registry staff earlier on, so we're just repeating information that has been already made with BRS. For members. We do expect that out of the 8 practice notes that have almost all been presented to BRS, a similar presentation like this will be made by the team that prepared the presentation for BRS for the general practitioners. So if you hear another call to come out and share with us, please, there's a lot of value that is coming out of this kind of engagements, and we encourage it to come out. May I call upon Emily Ngon to make a few comments? I'm looking, may I call upon Anne Kanaki to make a few comments?
Like Annie is experiencing some difficulties.
Okay, no,
she may not be able to comment at this moment.
No, I think because members do not have questions, I'm just randomly calling out, but I think we are coming to the end of that. If there's any member who still has any issue, I do hope that you are aware that there is a platform where the Joint Liaison Committees meet. It's called the JLC. There's a WhatsApp group. Probably you may ask Simon to share a link for those members who would wish to join that platform. You could be getting updates from time to time on issues that affect practitioners
or if you know a member who would benefit from joining that group, you can forward the details to us in the group, and we will be happy to add them. But the meetings of the JLC are 100% voluntary. We give you a time to the practice so that other members may benefit, and at the same time you benefit through the standardization of the practice by all members, that the quality of the practice and the quality of the interaction with VRS does improve. So please, we do urge our members, our practitioners out here, for us to come out and engage in a very healthy conversation with VRS and with fellow members on why certain changes need to happen. If we do not come out, no one to really speak for us on what to be done, or we will have to bear and suffer services that are not at par expectation. So we do request that we continue engaging and see to it that the practice reflects the quality that we promise our clients. And the registrar also does not suffer by getting substandard documentation because practitioners don't know or are not fully appraised on what needs to be done in any one particular application. So with those few remarks, it is 12:40.
Malachi, I've sent the link. I've sent the link to the JLC group, and can report that people are joining en masse. So thank you.
Okay. Okay. We might end up starting in JLC number 3 at this point.
Yeah, if you're in the first JLC, just you don't need to join the second JLC.
When we send updates to the first group, the same update also goes to the second group. So there's no need to join both. Unless if you join both, we will make you admin. So thank you, Simon, and thank you everyone for making the time to be with us for these 3 hours almost. We do appreciate your time, and we do wish you a very good afternoon. On behalf of the team, maybe if Emily has any parting shot, Nancy, parting shot, then we can call it.
I'll just be brief. Thank you for joining us. Look forward to future engagements in various platforms. The next JLC meeting is on the 19th of August. Plan to attend. Thank you.
All right, so mine is also just to say thank you all. It was a pleasure having you on this call, and thanks Malachi and the JLC for organizing this and for giving us an opportunity to train and, more importantly, to learn from our seniors and the rest of the practitioners. We look forward to such avenues more in the future and to continuing to support JLC activities. Thank you.
Thank you, everyone, and do have a good afternoon.